Good morning. I welcome those present and those who are viewing and listening. This is the 25th meeting of the Joint Select Committee on Finance and Legal Affairs. Today, the committee will convene its first hearing pursuant to its inquiry into the implementation of the new public procurement system, with particular focus on the operationalization of the Office of Procurement Regulation and the progress made by ministries and departments. Members of the public who are following this inquiry may send their comments via the social media platforms of the Parliament. I want to welcome officials and representatives of the Office of Procurement Regulation and the Ministry of Finance. We have both entities here at the same time, so as we proceed with the inquiry, we would direct questions to the various representatives and invite your responses. I want to now invite the Office of the Procurement Regulation first, and then the Ministry of Finance to introduce your representatives.
Thank you very much, Mr. Vice Chairman and members of the committee. And let me first of all say thank you for the opportunity to contribute today and to share what we have been doing as the Office of Procurement Regulation. On my right, we have our Corporate Secretary, Delrain Liverpool Young, and starting from my left, Mr. Robin Otway, Attorney at Law, Frederick Bowen, Board Member, Procurement Specialist, Nikolai Edwards, Board Member from the Youth Forum, and Pastora Brown, one of our staff members, who is the team lead policy development. Thank you.
The Ministry of Finance.
Good morning. Thank you, Chair. Good morning, members of the committee. Good morning, Office. My name is Michelle Durham-Kisoon, Acting Permanent Secretary in the Ministry of Finance. And on my right is my Deputy Permanent Secretary, Jennifer Lutchman. Thank you.
Okay, thank you very much. I am Clarence Ramrat. I'm the Vice Chairman of this committee, and I'm chairing the meeting today. I would ask the other members of the committee to introduce themselves, starting on my right.
Good morning, all. I'm Vidya Gaidin Gopi Singh, member.
Good morning, all. Taharka Ubika, member.
Thank you very much. And we are supported by the secretariat provided by the Parliament, including Mr. Ogilvy, who is here, and other members of his team. Now, we have three areas that we'd like to focus on today. The first is the state of the legislation. As we all know, the Act itself was passed, and there was a delay because certain amendments needed to be made. Those amendments have been made, and subsequently the board was appointed, the regulator was appointed, and we are aware that the regulator is conducting activities in the public domain. So in relation first to the state of the legislation and the timeline for full proclamation. The second area we'd like to deal with is the Office of the Procurement Regulator itself in terms of the operationalization of that office and your timeline in respect of being able to fully discharge the functions given to you under the legislation. And the third relates to the Ministry of Finance, which is the lead ministry in relation to the responsibilities under the Act and the operationalization of the ministries, the individual ministries, and the agencies which are subject to the Act. So those are the three areas of focus. Where are we in terms of the legislation itself and the proclamation of the legislation? Two, the Office of the Regulator and the readiness of the office to discharge all its functions. And three, the offices of the readiness of the various ministries and agencies to discharge the functions and responsibilities under the Act. So I would ask my colleague, MP Gaidin Gopi Singh, to lead us on the first area. And before I do that, I just want to invite first Mr. Lalchan and second Mrs. Durham-Kisoon to make opening statements if you wish to do that.
Thank you, Chair. Thank you very much, Chair. The office was established pursuant to the Act of Parliament, and it is to be governed by a board. The board was appointed on January the 12th by His Excellency, and we are fully constituted in terms of all 11 members, including the regulator. And to date, the office has been involved in hiring of key staff, stakeholder engagement and consultation, both in Trinidad and in Tobago, and working towards the completion of the draft regulations for submission to the Minister of Finance to take to Parliament, and the finalization of the handbooks and the guidelines to give operationalization of the Act. So we do look forward to some fruitful discussion this morning. Thank you.
Ministry of Finance.
Good morning, all. Good morning, viewers. The full operation of Act No. 1, 2015 will reform Trinidad and Tobago's procurement laws and systems so that both are consistent with the principles of good governance. The Act will govern spending of public monies by all state agencies, including all state-controlled companies, under a single regulatory framework that encompasses all stages of the procurement process. The Ministry of Finance, like all other entities, are subject to the Act, and we have been happy so far to facilitate the preparedness of implementation thus far, and we look forward to further guidance from the office. Thank you.
Okay, thank you very much. And just a reminder, one, to ask you to direct your questions or your responses through the chair. And the second thing is to make sure that you turn on and turn off your microphone when you're contributing. So thank you. I want to invite my colleague, MP Gayadeen Gopi Singh.
Thank you again, Chairman. I believe this might be to Mr. Robin Otway, the legal person. Right. I'm seeing that pursuant to legal notice number 150, and we got legal supplement Part B, volume 54 and so, you had certain sections of the Act came into operation in July 31st, 2015. So we have sections 1 and 25 and 62 and 63. My question is, those sections of the Act that have not been proclaimed, are there any, not deficiencies, but are they in any way impacting on the effectiveness and how the OPR functions?
Sorry, to be clear about your question, how do they impact?
And how is it affecting the effectiveness of how you run in this OPR?
In terms of what has been proclaimed?
Not been proclaimed.
Has not been proclaimed.
Yes,
well,
yes.
I think the word would be operationalizing.
Yes.
As I like to describe it, we are up, but not running. We don't have the teeth. Now, not all of the sections between 1 and 25 have been proclaimed. You will see that in some of them, only 1 or 2 subsections have been proclaimed. So in terms of, we have no teeth at the moment. We have no power to investigate. We have no power to inquire the actual teeth in the legislation. So what has been proclaimed allowed for the setting up of the board, the appointment of members, and getting us up. But with full proclamation, we should then be running. I personally am happy with the legislation I see. One could ask for it to be tweaked and a few amendments here and there, but I think by and large, it should allow the board, the Office of the Procurement Regulator, to make a major impact in terms of procurement and disposal of public property in an effort to minimize corruption, waste, and mismanagement. I hope I've answered the question.
Yeah. Have you identified these relevant sections that you believe to be tweaked or amended?
There's one that provides, pardon me if I'm not very specific, but there's one that, in terms of the actual section, there's one that provides that the procurement regulator shall dispose of real estate, I think it is. He actually real property is the term, real property. And certainly from my legal perspective, who will guard that guard? I do not think that is appropriate. There's another that I think breaches the principle of natural justice. It provides that if a person makes a complaint and does not appear, any party to a complaint proceeding does not appear, should there be any appeal, that that person who does not appear is not allowed to be heard or appear at the appeal. And I think that is in breach of the principle of natural justice, requiring a fair hearing, because there may be explanations, there may be valid explanations why a person did not appear. And even if he did not, for good reason, I do believe that, as I say, natural justice, having a fair hearing, hearing both sides, would entitle that person, even if he defaulted, even if he didn't come for no good reason, to be heard on appeal. Those are the principal concerns I have. I believe the chairman has one or two. Those are the ones that I could immediately identify. Thanks.
Of course, with the rule of law, that's a basic tenet in
Yes.
governing, the rule of law. And you're saying, so we need oversight then with the real estate with respect to the OPR dealing with real estate. That is what you're saying?
Real
we need
property.
oversight.
Real property, I don't think the regulator should be directly involved in disposal of anything, of real property. And real property, of course, can have particular or very great value.
I'm seeing pursuant to Section 16, you can appoint committees. Have you all appointed any committees, and what are those committees?
Should I pass over to the
Yes.
chairman? There I am on one.
Whoever can
But I believe
respond.
the chairman.
Yes.
Through you, Chair, we have not appointed any subcommittees under the Act. What we have done is appointed subcommittees of the board to help to expedite the like the operationalization of the office itself. One of the subcommittees that we are contemplating is the subcommittee relating to the disposal of public property. And that's one of the subcommittees that we are hoping to get going. And the chairperson of that subcommittee, we recommended for Mr. Otway to be the chairperson, and that they are now looking at setting up the terms of reference of that subcommittee, but the committee has not been appointed fully because we have to get persons with the fit and proper criteria to serve on that committee.
So is there any advertisement or so?
No, sorry, through your chair again.
Yeah.
We are in the process of developing the terms of reference. Once that is done and approved by the board, then we will go out and do the advertisement for selecting persons to serve on the board.
And you have remuneration packages and so in mind?
That will be part of the mandate to develop the remuneration and so on. But all that will be contemplated in the terms of reference.
So I believe also pursuant to Section 20, where you can establish this pension fund, all that is still to be worked on?
Yes.
Because
through you, Chair, what we have done, we have recently gone out for public advertisement for a broker, an insurance broker to be appointed. And once that insurance broker is appointed, there are two specific things that we will be looking at in terms of a medical plan and also a proposed pension plan to advise us on both fronts.
so what is the criteria for this insurance broker? What are you looking for?
I don't have the details presently, but we have it in a request for proposal. The details is in the request for proposal that we will be sharing. But there are basic things that we were looking at, for example, their experience in the various industry, and specifically things like their experience in terms of providing for medical and health, and also for pension.
All right.
There are minor areas like coverage for assets and so on that will be required also.
All right. I'm seeing in relation to Section 51A to 51M of the Act, you have to establish a Public Procurement Review Board. What is the status of this?
The public, Chair, the Public Procurement Review Board should be appointed by Excellency, the President. Our understanding is that 2 members of that board have already been appointed. The 3rd member, who has to be a retired judge, I believe that is still being done. We wrote Her Excellency, the President, on the matter, and we got a response that states that appointment is imminent. So we are looking forward to the eventual appointment. When that review board is appointed, they will then develop their own regulations and so on for approval as to how that body will conduct its affairs. It's supposed to be an independent body apart because they will have to review the decisions of this board.
And if I don't want the ministry to be left out, what you may think might be some of the challenges that these ministries are encountering in relation to satisfying the requirements of this Act?
Through you, Chair. Thank you. Through you, Chair. Thank you. Thank you for the question, member. One of the challenges ministries have expressed a concern of having access to knowledgeable and experienced staff. The other challenge pertains to Section 61(2) of the Act, which speaks to the appointment of a procurement officer. If I may just read it for you. For the purpose of this Act, a public body shall have a procurement officer who shall be responsible for public procurement and the disposal of public property for that body, and shall notify the office in writing of the name and designation of its procurement officer. Without the access to experienced and knowledgeable staff, it is envisioned that this is a major responsibility, and we are unsure of the availability of officers to accept that responsibility.
My apologies, Mr. Chairman, for not addressing my remarks through you. Humble apology.
Oh, that is fine. Mr. Lalchan, one of the areas that keeps coming up is the transition from the Central Tenders Board to the Office of Procurement Regulation. What has been happening in relation to that issue of transition?
Chair, we have had one meeting so far with the members of the Central Tenders Board, and the transition aspect of it, I believe, and subject to correction, that the ministry is working on some of that aspect for the transition. And what we see happening as one of the challenges in that transition period, the number of contracts that are presently being handled by the Central Tenders Board. With the full proclamation of the Act, the Central Tenders Board Act goes away. And therefore, those contracts that are being handled by the Central Tenders Board will eventually be transferred to the various public bodies that would have engaged the services of the Central Tenders Board. Our recommendation would be to see if some of the members of the Central Tenders Board who are working on those projects could be temporarily assigned to the various ministries to who they would have been working on those specific projects. But we have not had any detailed discussion in terms of details associated with that transition.
Is there a transition plan being put in place to effect its change from, because you'd have contractual issues, you'd have staffing issues in relation to the current arrangements with the CTB in relation to their employer, and the proposed arrangements for working with the regulator on a, whether it's a project basis, and then also those contracts or those the procurement that is in train. So you have existing contracts and you have procurement contracts that are in train, and you also have procurement contracts, arrangements that are arising every week as the cabinet, for example, approves the development programs for the various ministries. So is there a transition plan that takes us from the CTB arrangement into the arrangements under the law?
Chair, we have not been working on the transition plan, and we do have a concern that, as the PS would have mentioned, the staffing up of the various ministries and the capacity that is required for that transition, if it's not in place, there may be some issues associated with continuity. So that's something that we will have to address sooner rather than later.
On the issue of that raised by the ministry, I saw that, as I mentioned before, you've had outreach activities. I don't know if it is at the level of technical training or if it is now just introductory, but you interacted with more than 100 entities, but just as many did not participate so far. So I want you to just, in the context of what the Ministry of Finance has said, talk to us about those activities that you're engaged in with the state entities, the ministries and the state enterprises and the statutory bodies and so on, and the objective of that interaction, and whether that interaction rises to competency building, capacity building, or if it is just informational.
There are three types of meetings and interactions we would have been involved in. In the September, the one that you're referring to, Chair, would have been the detailed sessions we would have had with a number of agencies, the 100 and so. Before that session, in what we refer to as the stakeholder engagement and the consultation, there was a specific aim of those consultation in terms of the information gathering in regard to the draft handbooks and guidelines that were prepared by the UNDP. And those proved to be very useful because some of the feedbacks that came back to us was that many of our constituents believe that the handbooks and so on were a little bit overbearing and complicated. And it needed to be a little bit simpler to achieve the objective of the Act without watering down the handbook and guidelines. So we have taken that on board. The other big issue that we dealt with was the draft regulations, because there were some draft regulations prepared under the mandate of the UNDP, but they were found to be deficient. And we needed to get that completed. We had our consultant with us during that 6th session in Trinidad, and we got very useful feedback that led to the eventual completion of the draft regulations, which we only completed this week. So that was really the consultation. In addition to that, on October the 19th, we had a full consultation for a full day in Tobago. And the same things that we dealt with in Trinidad, we dealt with in Tobago. Before these consultations, we met with a number of agencies and so on, like the chambers, the Coalition of Service Industry, the Contractors Association. All those were done before the stakeholder engagements. So that's the second aspect of meeting. And the third aspect is our face-to-face meetings. And we have had, as you would have seen in the report, several face-to-face meetings in terms of the various ministries. For example, like this afternoon at 2 o'clock, we are meeting with the Ministry of Agriculture, the Deputy PS, and a team from the Ministry of Agriculture. So that is ongoing. We have also met with a number of the special purpose companies. On Tuesday, we would have met with National Flour Mills. We are meeting with UDCOT, NIPDEC, NP. All these are ongoing. And these face-to-face interaction is to deal with details as to how they are going to be ready for the implementation and the full proclamation of the Act. So the detailed discussion is where we believe we are gathering more momentum in terms of getting ready for the proclamation. The intention is, one is to sensitize the various constituents, make them aware of what is taking place with the Act. And you would have also seen a number of public advisories that we would have published in the newspaper, again, to sensitize the public. So that's one aspect, sensitization. When we have completed the revised version of the handbook and guidelines, we propose to have a number of other stakeholder engagements to roll out the handbooks and guidelines. And that will be part of a sensitization program mixed with a training aspect to upskill those who will require those upskilling. So we are doing it on a number of fronts, and that's some of the main areas that we are addressing.
Yeah, I just want to, before I switch to Senator Obika, well, first I should have thanked you for the submission that was made. It was very comprehensive, and it has assisted us a lot in terms of understanding what you're doing. I want to ask you, realistically, what do you see as a possible time frame for the transition from the current arrangements to the arrangements set out in the procurement legislation?
Thank you, Chair. And some of the critical path areas that we were looking at in terms of addressing would have been the regulations. So that's now completed in draft form to be submitted to the ministry. The handbooks and the guidelines, our time frame for the first full draft of the revised version is the end of November. So those are critical elements in terms of requiring for the full proclamation. Our recommendation would be to go for full proclamation after we have the regulations passed in Parliament. That will give us a time frame somewhere about probably end of February we are looking at. The database that we have gone out for tender for has a closing date for full completion by the end of February next year also. The database will also be critical in terms of for reporting and also in terms of pre-qualification of contractors. So we're looking at the end of February. Realistically, I think we should be fully operational and up and running by the end of March. That does not mean, and we are very sensitive to the requirements of a number of bodies in the public entities being ready. We will have to grant some transition period. I would suggest after March of 2019, and the suggestion is about a 6-month period to get the full transition. During that period, we will use to upskill and work on getting the ministry and the various public bodies as much prepared as possible. We cannot wait too long because the longer it drags out, I think we become complacent after the full proclamation.
Now the legislation gives you the power to have a transition period. Does it?
The transitional section.
Yeah, it does. And even
Transitional.
for the central tender board.
Transitional.
Yeah, 64.1 has to do with the central tenders board transition.
Right. So, because I'm happy that you laid out that timeline, because going back to what Ministry of Finance said, on your document, you've identified Section 13.1, which gives you the responsibility to set the training standards and the competence levels and so on. You've also said in that submission that you expect that the assessment of competency levels in the public sector would be completed by March 31st, 2019. So it means after that, when you've received the assessments, you would then, based on your timeline, use the 6-month period to upskill and to develop the competence. That is the idea?
Yeah, and Chair, what we have done is we have already drafted what we consider to be the key elements of the capacity development. And the capacity development will be at different levels. Some of the agencies would already be ready for full proclamation. For example, the larger public bodies or what we call the special purpose companies. And that's why you would have seen we have been meeting with these special purpose companies on a regular basis. In fact, some of them have already passed on their draft handbooks and guidelines to us to review. We have put it on hold because we wanted to get the regulations completed.
Right.
Once the regulation is completed, we can then go ahead and they will be ready.
So the training standards and competency levels would be in the form of regulations, or would it be policy documents within the Office of the Regulator?
It will be on 4 scales. One, to bring awareness in terms of what is required under the Act. The regulation forms the second pillar. The third pillar would be the handbooks, and the fourth pillar would be the guidelines.
Right, but which of those address the training standards and the competency levels for the ministries and the agencies and so on?
It will be the handbook and guidelines.
Okay.
That's where the rubber really meets the road. That's where the detail comes. That gives you the step-by-step approach to conduct the affairs of
procurement. And my final question before I move to Senator Obika. Are you contemplating making the Act applicable to certain entities or all?
I think it will be all.
Right, so, but does the Act give you the power to, in your transition, to make it applicable to those entities that you believe are in a position to comply with the requirements of the Act?
I'm not sure, Chair. I'll need to check that and probably revert. Robin?
It defines public bodies. What's public money?
Yeah, I think once it's...
A public body and companies that spend public funds, public money.
Upon full proclamation, it's expected that everybody will be required to follow the requirements of the Act.
Okay.
So that's clear. What I'm saying is that some of the bodies may not be fully upskilled, and we will have to work with these bodies in getting them ready over that transition period.
Okay, thank you very much. I'll hand over to Senator Obika.
Thank you, Chair. I have this question. It's the same question, but one of the prior questions, but to the Ministry of Finance. It has to do with the estimated time frame for the winding up or dissolving of the Central Tenders Board and the status of the temporary accommodation of staff at CTB. Madam PS.
Thank you, Member. Through you, Chair. The Central Tenders Board Act, according to legislation, will be repealed upon proclamation of the Act, the Procurement Act. So the Central Tenders Board continues to function until such time. That said, the Ministry of Finance is working with the Central Tenders Board and for the Tenders Board so that officers can exercise their options under the Act so that there will be a smooth transition. The Ministry of Finance is working with respect to getting all pension and leave records updated. As you would appreciate, once the Central Tenders Board is dissolved, we need to ensure that officers' pension benefits are fully, their records are intact and their benefits can be calculated as of that time. Okay? The timing, if you understand, pension leave has to be calculated up to a particular time. And until such time until we have a cutoff date, it's a moving target. All right? So we're working with that. We have told our divisions and all ministries to prepare, have those records prepared, so that we keep moving the date. As of now, we said up to the end of the calendar year, so that records will be up to date and probably will just need to be further updated up to the time that the date is given to us.
And also the status of temporary accommodation of staff assigned to CTB.
The Central Tenders Board continues to function and their facilities on Upper Frederick Street, so that their work isn't interrupted and they continue to operate from those premises.
A follow-up question, and this from this after your answer, I would go to the procurement regulator. It has to do with staff morale and tenure. If you can give an idea as to what type of tenure they have, whether it be contracts, short-term, 2 years, 5 years, or if they are permanent on the establishment at the Central Tenders Board. All right. I assume that they are permanent based on the pension arrangement. The other question would be, given that they are winding up, is there any exodus of any type of staff from the CTB? Are they anticipating being rehired in the new procurement regulator, or are they being prepared for exit? And if so, how is the ministry supporting the career aspirations of those persons at the CTB?
Thank you for the question. Through you, Vice Chair. The tenure of the officers, I don't have the establishment before me, but the Central Tenders Board comprises various classes of officers. Maybe I can deal with the officers who are most known to us, the officers called contracts officers. And when I say contracts officers, I'm not saying officers who are on contract employment. Those are officers, that's their designation, and they are the ones who actually manage directly the procurement process. Most of them are substantive in their positions. Most of them, if not all, I mean, I can get this information for you, but they are acting in higher positions. There are also officers who are acting outside of the Central Tenders Board in higher positions. And there are also officers, particularly in the clerical stream and secretarial stream, who are acting within the Central Tenders Board. With respect to exodus, the officers, there has been retirement. We have seen 2 directors of contract and at least 1 assistant director of contracts. They proceeded on retirement. We have an acting director and acting assistant director of contracts at the moment. The morale, as you would expect, the officers are anxious. We try to reassure them, as in accordance with the Act, that they will be offered nothing less than what they presently hold. With respect to the technical officers, the contracts officers, the demand for their services in the wider ministries is greater than the supply. All right? So we don't anticipate that for those officers who choose to remain in the wider public service, we don't anticipate any problems there. For the officers in the administrative, clerical, and other classes, for those who choose to remain in the wider public service, we will work with internally and with the Service Commissions Department to ensure that they are placed in accordance with their seniority. And I spoke to preparation of pension and leave. That is ongoing. I think
you answered every question. So I thank you, Madam PS. So this question now has to deal with the procurement regulator. And there are two questions basically that I have there. It has to do with, I think the chair already asked questions relating to the readiness of ministries and so on, which really is the work of the regulator. But regarding the staff requirements, I see here that all staff are employed on a contractual basis for 2 years. Now, persons at CTB would have had tenure, the majority, based on what the PS, if I'm correct, based on what Madam PS just said. And we know that not having tenure can affect someone's functioning, particularly when their contract is about to expire and they are waiting on the CPO to remember that they are there so that they can get some form of extension. What in your view, is it positive that the only 2-year contracts have been extended to the staff at the regulator?
Thank you very much, Member, and through you, Chair. When we looked at the setting up of the office, the board discussed it at length, and we weren't sure as to how this office will eventually pan out in terms of the requirements. We may eventually have to have more investigators, auditors, legal personnel, policy officers, and so on. So what we did was to decide that we will go with the 2-year contract because the ultimate aim is to have permanency in the employees of the office. That's the ultimate aim. Within that 2-year period, it gives us the opportunity to really assess what will be the requirements of the office going forward. And before the expiry of the 2 years, we will have to make a decision because we would not wait until the 2 years has expired to start thinking about the permanency, because then my own staff and the staff at the office will start thinking about whether or not they should leave. So before that happens, we will have to take some decision at the board level to ensure what the organization would eventually look at, because some of the positions may go into permanent position, some may remain contract, and some may no longer be required. And we may want to consider outsourcing some of the positions. So that's the reason why we went with 2-year contract. Nothing prevents us from incorporating any member of the Central Tenders Board, because we also have a provision under the Act if somebody from the Service Commission, I believe, wishes or is successful, they can be seconded into the office at the same terms and conditions, and the superannuation benefits and so on will be held intact. And they can be seconded for up to a period of 5 years. So those are the things that we will be looking at as we move forward. But it's really to settle the organization, get the necessary skills that we believe is required at this stage, and then as we move forward to determine which positions will become permanent.
Yes, I want to put it to you, Chair, that apart from public servants who are on secondment, because they still have tenure, if anything happens at the end of their contract, if it's not renewed, they can revert to their substantive post in the public service. Having myself worked in the public service on contract, all right, in a position that was supposed to have been made a permanent position, and I started in that position in 2008. That position still, in that particular ministry, is still subject to the CPO conditions of contract and so on. And practically everyone who was employed, except one, have moved out of that position because of the insecurity of tenure. When your contract comes to an end, you have month to month and so on. These persons are going to be managing, they're going to be responsible for accounting to the public funds and projects in the billions. And I think some positions should be seen as a regular, they will be part of the structure going forward regardless, some of the positions on the org chart that you presented. So I believe that the board should look at revisiting that, and especially where you have professionals who are coming in who may not be from the public service, They may want to see something like a 5 to 10 years. But there's a more comment. And I know it is in sync with what you are thinking. It's just that you're considering the positions in question. The question that I also have regarding the positions is on the schedule for the Central Tenders Board. I see architect, civil engineer, mechanical engineer, quantity surveyor, economist, engineering assistant, draftsman. And on your org chart, I'm not seeing any of those positions. Can you shed some light?
Yeah, through you, Chair. Some of those positions would be, if you look at under the capacity development and policy development, you would see 5 officers, 3 in capacity development and 2 under policy development. That's where we believe that we'll be able to get the benefit of that expertise in terms of developing the policies and procedures and also assisting in capacity development with the various public bodies. So those are the areas. Additionally, we believe that under the audit and investigations unit, where you would see 1 team lead and 4 positions, 2 investigators and 2 reviewers, we believe that those specific areas also could be addressed there, where we have the expertise to go out and conduct audit and investigations, not the traditional type of financial audit and so on, but specific audits in terms of contract management and so on. So those are the areas, I believe, those 3 areas where we can benefit from the expertise.
So I have one last question, and it is regarding any complaints that would have been received by your office, even though the act isn't fully proclaimed, because I mean, in Trinidad and Tobago, there have been questions asked about certain billion-dollar projects and multi-million-dollar projects, such as purchasing of the ferry for Tobago, for example, in particular. Have you received any complaints, and have you dealt with it in any form or fashion?
Through you, Chair, yes, we have not only received comment, member, through you, Chair, but also what we have been doing is monitoring on a daily basis some of the issues in the public domain. Although we cannot start investigation and so on because the act is not fully proclaimed, what we have done is to set up files for all the complaints that we have been having and also responding to the persons who have made complaints and giving them the assurance that once the act is fully proclaimed and we do have jurisdiction, we will exercise that jurisdiction. We have a number of the issues in the public domain that we have been tracking, and as information comes to us, simple things as extracting it from the news, taking the newspapers, the clippings and so on, and we are preparing permanent files on those issues for the eventual, whether or not they fall under the jurisdiction, we will then exercise our option.
Okay, thank you very much. I have member Gayadeen Gopi Singh has some closing questions to ask, and then I just want to direct you to 3 areas for just some updates before we close. So I'd hand you over to MP Gayadeen Gopi Singh.
Thank you, Chair. Mr. Lalchan, just to follow up with Senator Tahaka, you said that you're setting up files with respect to some complaints and so, that you're closely monitoring some of these complaints that people are bringing forward. When the act is proclaimed, can you retroactively deal with those complaints?
Yeah. Thank you very much, member. Through you, Chair. What we have done under Section 70, we have requested, and 2 opinions we have gotten so far. One from the Honorable Attorney General in respect of how do we interpret Section 70, and another from an independent senior counsel, giving us the interpretation of Section 70, whether or not we will have the jurisdiction to go before the full proclamation and open up any case that would have been in transition. We have only recently gotten the opinion from senior counsel, which we'll be discussing at our board meeting on Wednesday coming. At that stage, we will then decide, based on the opinion, because my legal advisors and so on will still have to interpret for the board what is our jurisdiction. So we have taken that step in getting legal advice as to how we proceed.
I'm just asking questions that were already enunciated in advance here. So that's why I'm just asking follow-up questions. You know, anytime we want to get into a new venture, we always talk about best practice. Are you using any model, perhaps international, that is guiding the OPR with respect to public procurement?
Through you, Chair, what we found when we took up our positions, the UNDP was given the mandate to assist in the preparation of like the handbooks and the guidelines and so on. So those we believe were very comprehensive, and they incorporated a lot of best practice from various jurisdictions. In fact, when you look at some of the handbooks, you'll almost see entire sections coming to bear on the handbooks and the guidelines. So that's one part of it. When we went out to get a professional person to assist us in the regulations, we got a very eminently qualified person who has worked in over 60-something countries. And that person brought a lot of the best practice internationally to help us. Not only did he help us with the regulations and the drafting and so on, but he gave us some very good suggestions in terms of how we could improve in terms of the handbooks and the guidelines. And we have taken all those on board. So the answer is yes, we have gotten best practice from the international consultants and also from the UNDP and all the good work that they would have done in preparing us to take office. We also had offer from the IADB in terms of assisting us with the e-procurement aspect and bringing best practice, which is something that we are looking at also in conjunction with the databases. How do we bring to bear some of the electronic procurement systems that is out there and already in operation in various jurisdictions?
That's my final question. You also spoke about 4 different pillars. One you said was the handbooks. You have to do so many different aspects in putting and pulling these things together in a more cohesive way. Do you have any restraint, or what are the limiting factors with respect to money? Do we have money to do all these things?
I must say our friends in the Ministry of Finance have us adequately financed. We do have, and we have gotten the drawdown that was set aside for the operation of the OPR for the 2017-2018 period, and we have already received our first drawdown for the 2018-29 period, and I believe, based on our experience so far, we will be adequately funded.
That's very good news.
Thank you.
Thank you very much, Mr. Lalchan. I just want to close by asking you very quickly about three areas. One is the issue of disposal. Now, disposal now includes the disposal of land by the state. But I'm more focused on this vexing issue of disposal of fixed assets by the state. As you go around the country, you see, and as you go in the compounds of ministries, you see derelict vehicles, discarded computers, small items. The current arrangements for disposal are very frustrating for ministries. I want to ask if you've addressed your mind to this issue of disposal, not state land. I understand that regulations would govern disposal. Yeah. That is one. Second is this, in your response to us, you've identified 2 areas in which the legislation should be amended. And you've used very strong language in terms of the need for that. You've also said it's been brought to the attention of the Ministry of Finance. So I just want to ask you about if you have anything further on those 2 amendments. And the third area I would get to when you deal with the first 2.
Thank you very much, Chair. The first one, the disposal of assets under the guidelines and handbooks, we are recommending procurement and disposal committees for each public body. And that committee will be responsible for developing the internal procedures to be followed in conjunction with the office, because every procedure under the guidelines and handbooks must be approved by the office. So the recommendation is to set up these procurement and disposal committees to deal with the disposal. It will be guided by the regulations that we have put in place in terms of the disposal, and also the handbooks and guidelines will cover the detailed process to be followed. So the answer is yes, because we have been getting a lot of requests for multi-million-dollar write-off in terms of the disposal. And it seems to be that a number of these things are being held in abeyance until we get to a position that they feel comfortable to go ahead and dispose of it. So that is the first answer to your question, Chair. The second one, in terms of the two issues that we would have mentioned under 16 and 17, 16, 17, and 18, one is during the discussion with the consultant in the forum, he indicated that the Act specifically speaks to when you enter into these government-to-government relationships and so on. If there is any issue with procurement, procurement has to follow the Act. The international lending agencies themselves requires that you follow their process. And we believe that there may be some concerns in terms of conflicts where either you follow the international lending agencies' requirements or you follow the Act. And therefore, there could be some contention as to whether or not the funding will be released. That does not necessarily mean that the Act has to be amended. However, we have to be aware that that could be a concern, and that's why we brought it to the attention of the Ministry of Finance to deal with it at that level. So the other area is really a red flag that we were flagging in terms of, in some cases, for like international procurement, when you're dealing with some of the big companies, they come with their standard form of contracts. And therefore, you are almost required to follow their standard form of contracts. And what we are saying is that some of the requests for proposal may not include our standard form of contract. And we are at their beckon. We are saying that this is something that we need to be aware of. But we believe that we will have mitigating steps that we can put in the handbooks and guidelines in terms of mitigating that, so that the public bodies are not disadvantaged, because sometimes you almost feel that you have to accept everything wholesale. But we need to put necessary mechanism in place so that we safeguard the public entities in terms of our standard terms and conditions of the contract. So those were the two issues really that we highlighted.
Okay, and the next area deals with in the Act and in your operation, you're likely to come across issues, you definitely will come across issues dealing with IT security, data privacy, cybercrime, and separately the issues of whistleblowing and conflicts of interest. I know you've engaged a Chief Information Officer. I wanted to know, in the context of cybercrime legislation, for example, which is the subject of a joint select committee that is sitting at this time, if you've examined the proposed bill, and if you believe that there are things in there you need to address, and on the wider issue of data security, IT security, and data privacy, given the operations of the regulator.
In terms of the new proposed act, I know our corporate secretary would have highlighted that to us, both that and the whistleblowing act also. So she have sent the information to us. We have not had the time as yet to go through it. In the preparation of our databases, one of the requirements that we have put forward in terms of internal control has to do with the issue of not only cybersecurity, but any issue in terms of accessibility, and all these different things. Simple things like as to where we keep our permanent records, whether it's in the cloud or on premise, and where would that information be held eventually, whether we are happy with where the cloud is being permanently housed. So those are the things issues that, and in the request for proposal for our database requirements, we have stipulated specifically what internal control mechanism that we require to safeguard the data. Not only that, but as an extension to that, the public bodies now, in fact, the biggest fine under the Act is in terms of record keeping, because it carries a fine of, I believe, $5 million and 10 years imprisonment. So we have to work very closely with the public bodies in terms of that aspect also of security of information. So IT information is one aspect, but on the whole, we are looking at the overall aspect of record keeping, retention, and submission back to the office and so on. So it's a comprehensive view that we are taking in terms of security of documentation and information technology.
Thank you. I want to invite the Ministry of Finance first, and then the Office of the Procurement Regulator to make closing comments before we close.
Thank you, Chair. We want to thank you and the committee for inviting us here this morning to clarify issues with respect to the rollout of the new procurement regime. This is an exciting time. We're on the cusp of a new era, and we look forward to facilitating the work of the office and also to benefit from the guidelines, both general and special, that the regulator may approve. Thank you very much.
Thank you very much, Chair and members of the committee. Since the appointment of the board, we have been working very hard to get things in place towards full proclamation. And we really appreciate having to share with not only the members of the committee, but the national listening audience and viewing audience. I want to take this opportunity to really thank the Ministry of Finance and all the other ministries who have been assisting us. All the stakeholders in all the public consultation, they have been very, very helpful. The UNDP, the IADB, and lastly, I want to really thank my staff and members of the board. For the first 3 months, literally had to sit sometimes at coffee shops while we get our accommodation to get the office running. The Office of the Parliament that assisted us in accommodation in terms of meeting rooms and so on for the first 3 months of our board meeting. So I really want to say thanks. And in closing, for the listening audience, this is a gift, I believe, the Procurement Act that was given to this country. And we all have a part to play in making sure that this becomes reality. Are we going to really continue to be same agent or change agent? This is a gift we have to really take on board, leave a legacy for our children and our grandchildren and this nation. I thank you, Chairman and members of the committee.
Thank you very much. As we close, I want to thank the media, the persons in the public gallery for attending, and for those who have been viewing and listening to the broadcast. I want to thank the Ministry of Finance and the Office of the Procurement Regulator. Most importantly, I want to thank my colleagues, Senator Ubika and MP Gayadeen Gopi Singh. We all have competing schedules, even within the Parliament. Right now, we have another Joint Select Committee. Some of us would have been required to sit there also if we could split ourselves in two. And I'm very grateful to have them attending, and of course the support from the Secretariat of the Parliament. I want to thank you very much.